Everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today we are going to discuss about Doctrine of Impossibility. A contract is an agreement to be fulfilled by the parties to the contract, and a contract to be valid must be capable of being performed. But sometimes the performance of a contract is or becomes impossible due to its own nature or due to some circumstances which are beyond the control of the parties, which renders the performance of contract impossible and the purpose of the contract ceases to subsist. Like most of the laws in India, Indian Contract Act 1872 is also influenced by English laws as Section 56, that is, an agreement to do an impossible act. This section talks about two impossibilities, that is, initial impossibility and subsequent impossibility. Initial impossibility implies that the impossibility exists at the time of the formation of the contract, which may be known or unknown to the parties. If it is known to the party, then the agreement is void ab initio, for example, discovering treasure through magic. In case of subsequent impossibility, the performance of the contract is possible at the time of the agreement, but subsequently the performance becomes impossible or unlawful due to some events which are beyond the control of the parties. For example, A agrees to sell his land to B. Later on, the land was acquired by government. The contract becomes void on the ground of impossibility. Some salient features of the Doctrine of Impossibility are: there must be a valid and existing contract between the parties. There must be some part of the contract yet to be formed. That part of the contract which is yet to be performed should become impossible or unlawful, and that the impossibility should be by reasons of some event which the promiser could not prevent. Some causes of subsequently impossibility or frustration are destruction of subject matter of contract, that is, if the subject matter of a contract is destroyed after the formation of the contract without any fault of the parties, the contract is discharged and no party is liable. Number 2, death or personal incapacity of the party, that is, when the performance of a contract is based on the personal skill, ability or qualification of a party, then such contract becomes discharged on the death, incapacity or illness of that party. A contract for personal service cannot be performed by an agent or a legal representative. Number 3, non-occurrence of contemplated event, that is, a contract becomes void on the ground of frustration if the expected event, which is the foundation of the contract, is cancelled. Number 4, government, administrative or legislative intervention, that is, sometimes a contract is lawful at the time of its making, however it may become unlawful due to a subsequent change in law or government policy. Contract is discharged by impossibility of performance. Number 5, intervention of war, that is, if a war is declared after the formation of a contract, all pending contracts with the residents of enemy country is either suspended or declared as void. If war is of short duration, it may be revived after the end of the war. However, if the war continues for a long period, contract will be discharged on the ground of impossibility. Cases in which there is no supervening impossibility are like the mere fact that performance is more difficult or expensive than the party is expected does not frustrate the contracted. Number 2, performance cannot be excused on the ground of commercial impossibility. A contract therefore is not discharged for frustration merely because expectation of higher profit is not realized or the necessary raw material is available at very high price. Number 3, strikes, lockouts and civil disturbance like riots do not terminate contracts unless there is clause in the contract providing for or performance in such cases. Some Indian case laws are like Satyavrata Gose versus Mugniram Bangpur and Company. The facts of the case are: the defendant company launched a scheme to develop the land into a housing colony. The plaintiff was granted a plot on payment of advance money. The company committed to constructing the roads, thereby making it suitable for residential purposes. The purchaser was to pay the remaining amount to complete the conveyance. Meanwhile, a large area of the land was taken over by the state during the Second World War for war purposes. The company attempted to revoke the contract on the ground of subsequent impossibility. The court held that dismissed the defendant's suit. The requisition orders were temporary in nature and no deadline was mentioned in contract for construction. However, it was obvious for some restrictions to be in effect during the war, thereby causing delay in the project. Therefore, this delay doesn't affect foundation of the contract. Now, critical analysis of this agreement is that an agreement enforceable by law is known as contract. Contract functions as a means of social benefit which can be either subjective or objective. Contract also regulates the transfer of risk which is inherent in any contractual relationship. However, Doctrine of Impossibility comes into the picture where one party fails to perform his contractual obligation as a result of any subsequent event, or if one of the parties knows that contract entered into is void ab initio, which renders it impossible. if the foundation of the contract is frustrated due to the subsequent events such as destruction of subject matter, death or incapacity, change in legislation or intervention of war, then it will work as a good defense as against the plaintiff. For example, if we look into the case of Krill versus Henry, as mentioned there, the court clearly excused the defendant from performing the contract as the foundation of the contract became impossible. Whereas if we see the Indian case of Satyabrata versus Mugniram, there the court dismissed the defendant's suit on the ground that delay in construction doesn't affect the foundation of the contract. These two cases show that a contract becomes impossible to perform only when the foundation of the contract becomes impossible. However, this doctrine may be regarded as the most socially utilitarian solution. In conclusion, I'd like to say that the doctrine of frustration came into being to deal with certain circumstances where the contract is frustrated without the fault of the either party. The law is dynamic and built according to the wants of the society. Maybe to an extent, doctrine of impossibility brings clarity on the conflicting situations, the supremacy of contract which supports the principle of absolute liability, and the principle of impossibility that a contract is discharged when the purpose of the contract has been destroyed by the change of circumstances. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.